hole in the ground next to this hotel, which will hopefully serve as a future venue for this great forum. And as was mentioned, I've had the opportunity as a participant to attend this forum. I was speaking with Frank Hoskins, Mr. Justice Hoskins, on the way in about the last time that I attended in Ottawa. And I must say, I always enjoyed and looked forward to attending this particular event when I was a practitioner. Now, I have to share with you that it seems that the venue might have been changed, because in my schedule it said World Trade and Convention Center, so I'll try not to read too much into that the venue was changed without telling you. I'm also reminded David's reference to John Crosby of a rather infamous occasion where he was addressing a optometrist convention when he was industry minister. And as he made his way to the podium, he noticed that there was an enormous ceramic eyeball as the backdrop to the podium. And so, for those of you, perhaps we have some Newfoundlanders present who've seen Mr. Crosby as he then was speaking at this optometrist convention, and he was sort of fumbling with his notes and his eyeglasses, and he kept looking over his shoulder, sort of deadpan, and finally he said, "I'm awful glad this isn't a proctologist convention." Now, Mr. Crosby could get away with those things. So I must say it is great to be home, and it's great to be with all of you. I sincerely welcome the opportunity to spend a bit of time with you, and I apologize that I'm not able to stay longer. I have a wake to attend to in my constituency of a very important individual, a family friend, so I have to attend. I hope nobody had difficulty traveling here. I know there was a lot of consternation about Hurricane Arthur, but thankfully it gave Nova Scotians, for the most part, a pass, although some are still cleaning up from the aftermath. I know other maritime provinces, Atlantic provinces, have had more challenges. But here we are, in a dynamic, historic city at an important time when it comes to criminal justice. And I'm pleased to be with fellow legal professionals to discuss the ever-changing environment that we all operate in. And a special welcome, if I might, to all of the Department of Justice officials who are joining us here. It was mentioned that I was just at a committee hearing with some of our finest who were presenting there along with me. And I do want to signal to them my appreciation for the hard work that they do and the support that they provide me as minister. On rencontre vos collègues cette semaine et en échangeant des idées avec eux, vous donnez expression à votre passion pour le droit, une passion que je partage avec vous. J'ai pris connaissance du programme de cette semaine et, à mon avis, ils mettent en lumière la nécessité pour nous tous et nous adapter aux changements qui s'opèrent dans notre société, qu'ils soient technologiques et ou sociaux. With rapidly changing technologies and modernization efforts, and I know that this is part of your agenda, we as legal professionals do have an important duty as agents of change. And that includes, of course, adaptation at times, transformation. Always mindful that we have to be attentive to the role that we play in ensuring greater access to justice. And this has been an enduring theme, I know, at many gatherings such as this. Over my first year as Minister of Justice and Attorney General of Canada, I've had the honor and the privilege to channel the shared passion that we have for the law into helping improve our justice system for the benefit of all Canadians. After almost 6 years as Defense Minister and Foreign Minister before that, it was a pleasant change for me to return to what I consider to be my professional career, which started in this city. As a graduate of Dow Law School, as a person who articled with the Attorney General's Department, I hearken back to those experiences in addition to recent experiences in two different departments, including the international law perspective in foreign affairs and the Judge Advocate General, which is a very important part of the Department of National Defense, and one that is perhaps little known and even less understood by Canadians. But it was very instructive, and those are a couple notable examples of recent experience that have shaped my view Ensuring that our system functions as efficiently as possible, I know, is a goal that we all share, as well as some of the modernization that has to occur in this rapidly changing world. To me, this means ensuring that justice, as the old saying goes, is not only done, but seen to be done. This is a well-worn phrase, but one that has resonated with me since the earliest days, and growing up in a province, being educated here, working here, while the Marshall inquiry was happening. Again, is something, in addition to my practice, that has always stayed with me. I've also come to appreciate how much perception is part of our part of our profession, and certainly part of politics, of public policy making, and even part of internal memos and discussions from time to time. There are certainly challenges, real challenges, that I know you will be discussing around unrepresented accused, the added complexity that often occurs in the charter era, provincial legal aid budgets that are under pressure, and process that sometimes seems to outweigh the practical delivery of legal services. I chose to practice law, like most of you, because I believe it is an agent of positive change for our country. It's a way to transform the law in being a practitioner. It seeks to protect. It is an important goal that we share to find efficiencies and effectively deliver real justice. I certainly enjoyed my time as a practitioner, including the family law, the legal aid work that I did prior to becoming a Crown attorney. And who knows, you may have to return to the practice of law when you're a politician, because there isn't a lot of job security. Unlike the current profession, you have to reapply every 3 to 4 years. So I try to keep current. I do have a unique and time-limited opportunity to shape our criminal justice system with the input of many. And in that time-honored tradition of democratic accountability, there is always a sense of urgency. My earliest days in Parliament taught me how to apply some of the skills that I think I garnered in a courtroom, and to bring them to the floor of the House of Commons, to bring them to committee work. In fact, I was thinking about my remarks in preparing for being here with you. One of the very earliest decisions out of the Supreme Court that was being discussed in Parliament when I first arrived there in 1997 was the Feeney decision, which dealt with exigent circumstances and the application of warrants. This seems to have come full circle when we're dealing with the recent decision in Spencer and cybercrime and the declared expectation of privacy with respect to police warrants. So over the last year, I certainly sought to hear firsthand from Canadians about their experiences in the justice system. Based on that input, I feel even more motivated to try to deliver effective, responsive, accessible justice. One of the questions that I asked in consultations was the level of confidence that Canadians have in the justice system, and particularly in the criminal justice system. How they felt they were being treated overall. And you know, those opportunities have informed and guided our government on various legislative initiatives. One thing that I heard time and time again, that I suspect you may hear as well, is that Canadians find the system very often intimidating, overwhelming, confusing, and inaccessible when it comes to the provision of core justice. And Canadians need to feel that we are responding as a profession to those challenges and responding to their needs. It is especially true for victims of crime. And no one could ever dispute that our citizens deserve to be treated with courtesy, with respect, with compassion, and inclusion, which are the underlying principles in our system that we hope to address with the Victims' Bill of Rights. In the first 2 months as Minister of Justice, I traveled to every province and territory, and I heard the personal and very often tragic stories from Canadians about their sometimes lengthy and difficult road to healing after being brought into the system through no fault of their own. Re-victimization was a phrase that I've heard far too often. And these stories affirmed my belief that their voices need to be heard at a more practical level and within our justice system. It was this very reason, as I mentioned, that led to the creation of the Canadian Victims' Bill of Rights, which is something that you will be interpreting and seeing before you in relatively short order. It's a way in which we will entrench in federal law clear rights to information, protection, participation, and restitution in some cases at the federal level. This is an attempt to recalibrate our system that has tilted, in my view, the scales away from victims and from their loved ones. Canadians also need to feel safe in the environment in which they live, and they need to be ensured and reassured that the consequences of breaking the law are commensurate to the crime that has been committed. And while rehabilitation will always be an essential element within our justice system, so too is denunciation and deterrence. And in fact, a feeling that consequences are real, sentences reflect society's abhorrence of certain types of offenses, particularly violent and sexual offenses. And this is a serious consideration for our government, and I know for all of you. As members of our chosen profession and representatives of your respective communities, we all have a role to play in protecting Canadians. There is no more fundamental responsibility for a federal government than peace and security of its citizens. One only need to turn on the nightly news to see, as they say, what's happening in other places. Syria, Afghanistan, parts of Africa, other hotspots in the world. And we need to not only feel safe, but also that our families are protected, and not just in our homes, but in our communities, in our workplace. And it's sometimes hard to imagine a world where seeing your kids off to school in the morning, there might be a possibility that you would never see them again. Or that stepping outside your door, you could be kidnapped or killed. And that's the reality in some places where chaos reigns, where there is no rule of law. And this isn't to make excuses in any way for the frailties of our own system or to suggest that we don't compare in that regard, but it's sometimes necessary to provide a perspective. And we've attempted to export a more robust system of justice to many parts of the world, places like Afghanistan, borders between Israel and Palestine, parts of Africa, more recently our efforts to renew our ties to Ukraine. And lawyers and judges, in my view, can play an enormous role, and do play an enormous role, in restoring a sense of calm and confidence in the rule of law. Always sensitive to local custom and to cultural interests. Canadians do it well. They do it extremely well. I saw firsthand the impact that not only soldiers, but people from CEDA and Foreign Affairs and the Department of Justice had in Afghanistan in helping to restore some semblance of a system of rule of law. And a long way to go. But as I mentioned, Canadians do it very well. And here at home, our government continues to look at ways in which we can improve our criminal justice system, including, in some cases, increasing penalties against serious and violent offenders, and maintaining the confidence of Canadians in our criminal justice system. There have been a number of recent cases in Nova Scotia that might be the subject of some discussion here that have, in my view, shaken people over their view of disproportionately low sentences for violent criminal offenses. And that is why we continue to work with all levels of government, all partners, vulnerable Canadians, legislation like C-26, which is a bill to toughen penalties for child predators. One of the more alarming statistics, and statistics of course don't tell the full story, but child sexual assaults are on the rise in Canada, up 3% over the last number of years. That's a clarion call to act. And it's not simply through criminal legislation, of course. It requires a lot more than that. Similarly, our bill in response to the Bedford decision, which is coupled with a $20 million allotment specifically to help with programming to prevent and provide exit strategies for those who find themselves in prostitution, who are victims, who are predominantly individuals who, given choice, given opportunity, would leave prostitution. And so it takes a holistic approach, but focusing on vulnerable Canadians, recognizing that individuals, in this case, in situations that were studied during the Bedford case, changing, adapting to the circumstances, taking instruction from the Supreme Court, and hearing extensively from Canadians, which we did, has led us to what I think is a very important bill. We also, as many would know, in Bill C-13 with respect to online criminality, have attempted to modernize existing investigative powers, not confer new ones, but simply enable police to obtain electronic evidence from the internet with judicial oversight, recognizing the need for the use of technologies being policed more efficiently and more effectively. And so, our government is also committed to treating the issue of cyberbullying holistically as well. And that is through the prevention, education, raising of awareness, and working together, again, with all levels of government, the police, and the entire criminal justice system. I would say that the bottom line is simple. We need to do more. We need to do more together. We need to do more to protect vulnerable Canadians. And in fact, Canadians should feel a sense that we are empowered to do so, and obligated, in fact, to do so. The harmful effects of things such as cyberbullying and fraud, and in some cases other acts against the public peace, are alarming. And just because it's happening online, for example, doesn't mean that it doesn't have real-world effects. And one sad truth that gives rise to legislation, and the fact that we, as I mentioned, are required to act, is that many of these types of offenses are more prevalent, like child sex offenses, like issues with respect to forced marriage. Again, there is a requirement that we respond. And so, we have to pursue a strong and active agenda, which I know you're doing here. We have repealed sections of the criminal code, in some cases, that we felt were inappropriate, like the faint hope clause. We have raised the age of consent to protect children from sexual predators. We've cracked down on impaired drivers, which is, as many would know here, still the #1 criminal cause of death in our country. And during my relatively short term as Minister of Justice, we passed a not criminally responsible legislation. We are shepherding a number of important bills through the House right now, including tougher penalties for the killing of police animals, trafficking and contraband, and of course the Victims' Bill of Rights, and the Child Sexual Predators Bill that I mentioned. By taking these steps, I believe we will strengthen our criminal justice system. We will react to the disturbing trends that have occurred, and we have an opportunity to go further in other areas. And so, while I'm very grateful for this gathering, grateful for the opportunity to speak with you, what I want to hear most is from you about your deliberations, about your input as to what you believe we could be doing better or differently. And I'm aware that provincial and territorial ministers are also very engaged in this process. We meet regularly. And so we've been looking at other ways to improve the criminal code. And impaired driving, as I mentioned, has serious consequences, and so we will be looking at ways in which we can improve that legislation in the fall. It will also require, as is often the case, dealing with a very busy parliamentary agenda. And so, we'll be listening. We are open to the input that we have always received from this organization, from the Canadian Bar Association and others. And we'll continue in particular to include provincial, territorial governments, law enforcement, Crown and Defence, non-governmental organizations, and of course the Canadian public in making these final decisions. We all have an integral role to ensuring Canadians are well served, that they have confidence in their criminal justice system. And I know you'll be doing your part in examining some of the important topics that you have on your agenda, including recent Supreme Court decisions. And I certainly appreciate the effort and the enthusiasm of the Federation of Law Societies in addressing the needs of our criminal justice system. We are all ambassadors for the justice system. We all have a duty to our fellow citizens. Law schools, law societies, law firms, and the judiciary must work with all levels of government. Your commitment to acting in the public interest on behalf of law societies across Canada and to upholding public trust in the justice system are essential to helping us to continually meet the evolving needs of Canadians. As we go forward, our government will continue to work in partnership with you. It's a common goal that we share in strengthening our justice system. I hope you all enjoy your time in Halifax. You're your evening here as you prepare for your deliberations. And if you can, stay another day. Take an opportunity to look outside of Halifax and see more of what this wonderful province has to offer. Again, I thank you for the invitation. Merci beaucoup et bonne conférence.